It is 6:01, so we're going to get started. Welcome, everybody, to Know Your Rights, School Discipline, Suspensions, and Expulsions. Thank you so much, Spencer and Megan, for being here. My name is Rebecca. I am the Executive Director of the Sarah and Neil Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law, and we are putting this webinar on this evening. And my job tonight is to explain Zoom just a little bit. So we do have the chat should be open to everybody. So if you have questions, you can put them in the chat or in the Q&A. I'll be watching the Q&A and the chat for any questions, but we'll probably hold them until the end. And other than that, I'm just going to introduce our panelists and let them take this away. So first up, we have Spencer Hall. Spencer is the CFCC and Truancy Court Program attorney. And in that role, she provides legal guidance and referrals to legal services providers, as well as individual advocacy and information about students' educational rights to empower students and families to become effective self-advocates. She often serves as a bridge between the Baltimore City public school system and our Truancy Court Program families, providing assistance on public benefits, inadequate housing, evictions, guardianship, and school discipline, all factors that impact student absenteeism. Spencer joined the TCP as a volunteer tutor during her first year at the University of Baltimore School of Law, and in her second year, she enrolled in the CFCC Student Fellows Program, during which she served as a law clerk to Judge Catherine Curran O'Malley. She then served as TCP coordinator from January 2015 until August of 2021, when she became our TCP attorney. Prior to joining CFCC, she served as the Linda Kennedy Fellow in Advocacy for the Homeless Persons Representation Project, and later as a tenant landlord program manager for Baltimore neighborhoods. She received a JD from the University of Baltimore School of Law and a BA in history from the University of Maryland, Baltimore County. Our other panelist this evening is Megan Berger. Megan Berger is the Assistant Managing Attorney of the Education and Children's Mental Health Team at Disability Rights Maryland, the state's protection and advocacy agency. She works on school discipline, school to prison pipeline, special education, and children's mental health issues, with a focus on providing legal representation to youth with disabilities who are involved with multiple agencies. Megan represents students with disabilities and their families in IEP, Section 504, and school discipline cases and appeals, investigates rights violations and reports of abuse and neglect, and engages in systemic advocacy at the local and state level. She previously worked in the Child Advocacy Unit at the Maryland Legal Aid Bureau, where she represented youth in the foster care system in court and in special education and school discipline matters. She is a former AmeriCorps volunteer who worked as a youth advocate in a therapeutic residential program serving at-risk youth. Megan graduated from the University of Notre Dame, summa cum laude, and the University of Maryland School of Law, magna cum laude. Thank you both so much for being here, and we look forward to your presentation. And I am going to set up the slideshow. There you go.
Awesome. Thank you. Are we ready to get started, Rebecca? All right. Well, thank you. As Rebecca said, my name is Spencer Hall. I am the Truancy Court Program Attorney here at CFCC. Just briefly, I want to talk a little bit about the Truancy Court Program and what we do. We are an early intervention program for students in Baltimore City schools who are struggling with their attendance and related issues. So we work directly with students and families in the schools to find out, the underlying causes for why students are missing school, why they're coming late to school. We're a small team, but we have a coordinator. Obviously, I'm the attorney. We have a social worker and a mentor. So it's really a holistic program, and we try to find the root causes of truancy and do whatever we can to help get kids to school. So with that said, why are we even here talking about suspensions and expulsions? Why is this an important topic? All of our data shows that removing a child from school has lasting negative impacts. So can really have a detrimental effect, not only on their education, but on their long-term future goals. It's part of what advocates refer to as school pushout. You might also hear the term exclusionary discipline to refer to these practices. So students who face suspension, we know, are at risk of poor academic performance, obviously, because they're being pulled out of class. They're more at risk of dropping out, not completing high school. They're also at greater risk of involvement with the juvenile justice system or even the adult criminal justice system later in life. Next slide, please. So even all levels of leadership in Baltimore City and in Maryland recognize that exclusionary discipline practices should really only be used as a last resort in the most serious circumstances. The goal should always be changing the behavior in a positive way and supporting students so that they can remain in school and continue their education. So I'm going to go ahead and really just cover the nuts and bolts. I'm going to talk about the different types of suspensions and expulsions and just give you a brief overview of what that process looks like. So here's a little list. I'm going to go into them in more detail on the upcoming slides, so we can kind of bypass this one. First one is in-school suspension. It's pretty self-explanatory. This is when a child is removed from their classroom, but not necessarily sent home from school. Technically, it has to be a removal from their classroom or educational program for more than an hour. So this is the kind of thing where teacher gets frustrated, student is sent to the principal's office, told to cool their jets for the rest of the day. If that's an entire afternoon, that is technically an in-school suspension. We don't see a whole lot of this right now in COVID times, just because staff is stretched a little thin. So we are seeing sometimes where schools previously would have used in-school suspension, students are now unfortunately being sent home for short-term suspensions. Either way, it is still a suspension. So the principal has to notify the parent. They have to send a letter home with the reason for the suspension. It is not, it's not considered a suspension if the student is removed from class, but still given the opportunity to complete work. Next slide. So short-term suspension. This is probably the most common. This is what we often see, especially in the truancy court program. So this is a removal from school for 1 to 3 days. So the principal, again, always has to provide written notice for these short-term suspensions. It has to include the reason for the suspension, but it also has to include the date that the student is allowed to return. In these instances, the school is not required to send any work home with the student. They don't have to be proactive about it, but the student does have to be allowed to make up any work that they missed, and they have to be allowed to do so without penalty. So if they miss an assessment, a test, or something while they're out, they do have to be given an opportunity to make it up for full credit. These short-term suspensions are for things like shoving, pulling a fire alarm. It's one of the things that can be punished with a short-term suspension. But they need to be serious, but not the most serious of offenses. So longer-term suspensions, these are ones that last 4 to 10 days. So again, has to be accompanied by written notice with the reason for the suspension and the date the student is allowed to return. For short-term and long-term suspensions, the school also has to offer the parent a conference to discuss the reasons. The parent doesn't have to attend the conference, but the school is required to offer it. In these instances, for these longer suspensions, we're talking up to 2 full school weeks, the school has to provide the student with daily assignments. They also have to assign a staff member, a teacher, or administrator who will check in and grade the assignments on a weekly basis. Longer term suspensions are for things like fighting, certain bullying activities can rise to this level. Interestingly enough, in the Baltimore City Code of Conduct, a long-term suspension can now be used for intentionally coughing or sneezing on a student. That is a new one in these COVID times. I haven't seen anyone removed for that yet, but it is in the Code of Conduct. So extended suspensions are where we're getting into a little bit more serious behavior. Extended suspension, again, 11 to 44 days, so a much longer period of time. We're talking a much larger disruption to the student's education. This is the type of exclusionary discipline that actually has to go beyond the principal. For those shorter suspensions, it's really up to the principal. They have full discretion. For a suspension that's longer than 10 days, the principal has to provide a report to the school district. The school district has a duty to investigate it and also to schedule a conference with the parent. And that conference is supposed to happen within 10 days. The district representative is the one who makes the ultimate determination about these extended suspensions and also expulsions. Oh, and Rebecca, I do want to note that if you'll go back to that for a second, just to give it some context, extended suspensions really are reserved or should be reserved for pretty serious offenses. So things like physically attacking another student or a staff member, causing bodily harm, or things like selling or distributing drugs or alcohol on school grounds. And expulsion. So expulsion is the removal for 45 days or more. That's the legal definition. But expulsion really is essentially the removal of a child permanently from their school of origin. So again, very similar procedure to those extended suspensions. Principal has to write a report to the district. It's ultimately up to the district representative to make a determination whether that expulsion is warranted. And those are things like bringing a gun to school or sexually assaulting another student. Those are the most serious of offenses. Oops. And alternative placement. So when we talk about the shorter term suspensions, I mentioned that the school has to provide work that the student can complete at home and provide someone to do weekly check-ins. With these longer term consequences with extended suspensions, of 30 to 40 days or for an expulsion, not only does the district have a duty to provide work, but they can also choose to put a student in an alternative education program. So that can be an actual alternative school. We do have some of those here in Baltimore City. We now have virtual school options. Students are now being diverted to those if they're being expelled. And if a student is transferred to another school for any disciplinary reason, it is effectively an expulsion, and that can be appealed as well, even if the principal doesn't follow the expulsion procedure. Illegal send homes, I want to make just a quick note about these because I think Megan's going to talk about them a little bit in her part two. But illegal send homes, it's a term that advocates use. It's not technically a legal term, but these are basically informal suspensions. So this is anytime a student is sent home, but not given the proper paperwork, which also means it's usually not put into the school system as a suspension. And you can take a very cynical view of illegal send homes. Schools might do this because they want to keep their suspension numbers low. They don't want to report to the district that they are suspending students. But it's also possible that front office staff aren't aware of the rights and obligations that they have when they're sending a student home. So appealing an extended suspension or expulsion. If your child is facing one of these, either Senate suspension or an expulsion, you do have the right to appeal. The appeal actually goes to the local school board. So it would go to the Board of School Commissioners. The appeal must be made in writing within 10 days of the initial decision. And the school board will hold a hearing within 40 days and make a determination. These are generally private hearings, but the parent can actually request a public hearing if they prefer that the matter be public. So these are just general tips to keep in mind. Students cannot be suspended for infractions like skipping class, being in the hallways, being late to school. Anything attendance related, they can't be suspended for that. And not wearing a uniform. This is a big thing for us, especially with the illegal send homes. We often find that schools will turn students away at the door if they're not compliant with the uniform policy, and that does count as an illegal send home. Pre-K, kindergarten, first and second graders cannot be suspended or expelled at all in the state of Maryland unless there is an imminent threat of serious harm that can't be lessened by other interventions. So it's a very high bar for using exclusionary practices for the youngest students. Students with disabilities cannot be suspended for more than 10 days if the behavior is related to their disability. And I'm going to save that since Megan's the expert on that. She'll touch on that too. Other things to keep in mind, only the principal has the authority to suspend a student. Teacher cannot suspend, cannot tell the student to leave school without going through the principal and the proper procedures. As I noted over and over again, intentionally on all those slides, written notice is key. For any suspension or expulsion, the principal is required to provide that and also to offer the conference with the student and the parent. The last note on this slide, student must be admitted on the assigned return date, regardless of whether or not a parent has attended a conference with the principal. It's a mouthful. I bolded this one and put a star next to it because we do see this a lot. I truly believe it's a miscommunication and a misunderstanding, but I think a lot of school staff are under the impression that a parent has to come to school with the student on the return date, and that's simply not true. We've been in schools where student is suspended on Wednesday and told that they could come back on Monday, but mom's not available because of her work schedule, and so the student doesn't return until Wednesday. And so the student has now missed another 2 days of school, which are unfortunately unexcused absences. So that's a very important piece to keep in mind as well. So just general tips when you're advocating for your child, if you're facing a suspension or expulsion, keep good records, document everything. If the school's doing it right, you're going to get a letter with the necessary information. If not, if it's an illegal send home, make note of what your child was told. When they were told they could come back, what they were given as the reason for the send home. If you have a conversation with the principal or any front office staff, make sure to keep notes about that. And it's really important to talk to your child, get their side of the story, because if you do go in for that conference with the principal, it really is the opportunity for them to tell their side of the story with you kind of as their backup. Another thing to keep in mind is that under the Baltimore City Code of Conduct, the administration has to consider all of the relevant circumstances. They are really required to look at the whole child, including any past discipline issues, what the child's stated reasoning was for the behavior, their disability status. So when you're advocating for your child, it's up to you how much you want to share, how much of your business you want to share with the principal. But if your child is grieving the loss of a loved one, or your family is experiencing homelessness or some other sort of instability, and your child is really struggling with that, or your child has been bullied, and this was just finally, a reaction, a breaking point. Those are things that the principal should know. And if you are facing an extended suspension or expulsion, it is really best to speak with an attorney. We are so lucky. We have a wonderful resource here in Maryland. It's the Maryland Suspension Representation Project. So they provide free legal representation if you are facing any of these exclusionary practices, and they have a great website and a helpline that you can call if you need to get some legal advice. All right, and with that, turn it over to Megan.
Great, thank you. Hi, everyone. So I'm going to talk about school pushout, and I'm also going to talk about a little bit about special education and Section 504 and how, that's students who have disabilities with IEPs or 504 plans have some additional protections if they are subject to exclusionary discipline. So first of all, we know that school pushout does not work. It doesn't address the underlying causes of behavior. As Spencer said, it does not get at the root causes of the child's behavior. It doesn't teach kids how to improve their behavior, and it doesn't make schools safer. We also know that it's used for minor subjective behaviors. Statewide in Maryland, 36% of suspensions and expulsions were for disrespect and disruption during the 2018-19 school year. And disrespect and disruption are subjective behaviors. Implicit bias can play a role in identifying disrespect and disruption, and which students end up being more harshly disciplined than others. We also know from the data in Maryland that most school-based arrests are for run-of-the-mill fights, disrespect, disruption, and property offenses. And so this is just a graphic showing for the 2018-19 school year, statewide arresting offenses. And again, you can see how it's, fighting without weapons, it's disrespect, disruption. It sort of just shows you the different offenses where students are being subject to school-based arrests. Another concern about exclusionary discipline and school pushout is that we know from years and years of data, extensive data demonstrating that exclusionary discipline disproportionately impacts students of color. In Maryland, it disproportionately impacts Black children, and it also disproportionately impacts students with disabilities. And so this is a graphic that shows, I like this slide because it shows that in every single school district in Maryland, Black students are disproportionately subject to suspensions and expulsions and to school-based arrests. And so the green bar is Black students as a percentage of the student population. The red bar is their percentage of school arrests, and the blue bar is their percentage of suspensions and expulsions. And so it's happening in every single district, and this bears out nationally, locally. And we'll see on the next slide, there is similar disproportionality for children with disabilities. And again, that is, happening in every district in the state of Maryland. And I will also say that youth and children at the intersection of race and disability receive the highest rates of exclusionary discipline, and we know that from the research and the data too. So Black students with disabilities are receiving the highest rates of exclusionary discipline. And so that's why, school pushout, exclusionary discipline is a huge concern. And there's sort of advocates across the state and across the country working really hard to limit the use of exclusionary discipline in schools. And in Maryland, as Spencer talked about, there are fairly progressive discipline regulations in place that say the letter of the law is that, exclusionary discipline should be used as a last resort. And you can only suspend students for 10 days or more, for really serious offenses. And so that does not always play out that way, but part of our job is, advocating for students and holding the school systems accountable. So now I'm going to talk a little bit about policies and procedures around special education services. And so some students have IEP plans, and some students with disabilities may have a Section 504 plan. And so I'm going to just talk a little bit about the differences. IDEA is a federal law that stands for the Individuals with Disabilities Education Act. And that is for students who have a disability that adversely affects educational performance and who require special education designed to meet the child's unique needs through an individualized education program, and that's that IEP. And a Section 504 plan is for students who require accommodations to access the same free appropriate public education that is available to children who are not disabled. And so those are two federal laws, the IDEA and Section 504. And so what does Section 504 do? At its most fundamental level, Section 504 is an anti-discrimination statute. So it prohibits discrimination in federally funded programs against individuals with disabilities. It entitles students with disabilities to participate fully and without discrimination in school programs. And so for those students who have a disability, but they're not eligible under the IDEA because they don't require specialized instruction, Section 504 requires that the students still receive reasonable accommodations in regular classes with related aids and services, if necessary. And so reasonable accommodation means it does not require a fundamental alteration of the child's education program, and accommodations and services should be set forth in a Section 504 plan. So if you have a child with a disability, there may have been an IEP meeting and a team may have said, well, they're not eligible for an IEP meeting, but they may be eligible for a Section 504 plan. And that plan it's a legal document, and it's usually a piece of paper that spells out what your child's accommodations and services should be. And another important thing to know about Section 504 is that it requires an evaluation prior to a significant change in placement. And that will sort of be implicated in some of the discipline stuff that I'll talk a little bit about later. Okay, yep, great. And so to be eligible under Section 504, a child is found eligible if, based on evaluation, he or she has a physical or mental impairment that substantially limits one or more major life activities. And so this is just a list of major life activities. Oftentimes for students, they may have a Section 504 plan for learning, reading, concentrating, thinking, communicating. But all of these disabilities are eligible. Okay, and so now we'll switch gears and talk about the Individuals with Disabilities Education Act. And if you have a child with an IEP, then they have been found eligible under the Individuals with Disabilities Education Act. And so what does the IDEA do? The two sort of main tenets of the law, one is FAPE, and that stands for Free Appropriate Public Education. So all children with disabilities have available to them a free appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. And the other main principle of the IDEA is LRE, and that stands for Least Restrictive Environment. And so the law says that to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are not disabled in the least restrictive environment. And who is eligible under the IDEA for special education services? Children with disabilities from birth to 21 who, because of their disability, require special education and related services to access the general education curriculum. And so it's not enough that your child may have a disability, but that disability also has to impede your child's ability to access the general education curriculum. And who decides whether a student is eligible for special education and receiving an IEP? That's the IEP team. So the IEP team determines that eligibility. And the parent, you as the parent, are really the most important person on that IEP team. You know your child the best. You know your child's strengths and weaknesses. And so the parent is really a critical member of the IEP team.
Can I just ask a quick question here?
Oh, sure.
Who else is on the IEP team?
That's a great question. So there is usually the, just in sort of practical terms, usually the special education chair or the IEP coordinator is on the IEP team. Your special educator is on the IEP team. A general educator is on the IEP team. Someone who can leverage resources, usually it's an administrator, but an administrator or other person from the district who can leverage resources and make decisions at a higher level if that's what's needed. And so I know a lot of times we'll hear from parents where they're saying, I went to this IEP meeting, but it was just two people. It was, his one teacher and the IEP chair. And that, legally, that does not meet the requirements for a full IEP team. And the reason that that's important is because the IEP team is supposed to be a gathering of professionals who know your child and can all sort of, share perspectives and use their expertise to sort of figure out what supports or accommodations your child may need to access the curriculum. And so this is just a list of disabilities that may qualify a student for special education services if, again, the disability is, impeding the student from making progress in the general education curriculum. And I will say other health impairment, oftentimes and it sort of says that includes ADHD and Tourette syndrome, among other health conditions. And so generally speaking, this is just a graphic that shows what the IEP process looks like. And so it starts with a referral. So it's usually, a parent, or maybe the parent speaks with a pediatrician or some other, loved one in the child's life. And there might be a suspicion that the child has a disability, or maybe the parent's getting phone calls from the teacher, saying that the child is having some challenges accessing the curriculum, and there's a suspicion that there may be a disability, or maybe that your child has a disability. And so you refer your child to the IEP team. What does that mean? It usually just means that you write a letter or you send an email, and you always want it to be in writing and dated, saying, I would like my child to be evaluated for special education. And we advise parents to send that letter or email to the principal and the special education chair at the school. And a lot of times schools, you can just look on their website or call the front desk, and they'll be able to tell you who those people are. So parents usually can refer their child to the special education team. And then there's a meeting of the IEP team. So all those different individuals come together, and the parents part of that team, and you talk about all areas of suspected disability. And the team determines whether they're going to provide assessments and evaluations to determine disability and how that disability may be impacting the student. And so then there's usually an evaluation process where there's assessments. The parent has to consent to the assessment. So maybe the child's going to have a cognitive evaluation. There might be academic testing. There might be a speech language test. There might be physical therapy or OT assessment. And so all of those assessments and evaluations are done. And then the IEP team comes back for another meeting, an eligibility meeting. And that's where all of the professionals that did the assessments come, and they share their reports with the parent and the whole IEP team. And the IEP team discusses the assessments and makes a determination of whether the student's eligible for special education. And if the student's found eligible, then that same team sits down at the table and develops the IEP, the Individualized Education Program. And they also, after sort of creating and developing the IEP for the student, then they determine the placement of the student. Is the student going to receive services in the general education setting? Are they going to be in a self-contained classroom? Do they need a placement like a non-public school, a more restrictive placement? And then once that initial IEP is in place, every year, once a year, there's an annual review. So at a minimum, if your child has an IEP, you should be getting invited to an IEP team annual review at a minimum of once a year. If there are issues, if you have concerns, if your child's struggling, you as the parent can always request an IEP meeting. We work with families where there might be 10 IEP meetings in a school year. It just depends on the student's needs, how often you need to get back to the IEP team table. So as a parent, don't be afraid to reach out and say, I have concerns, I'm worried. I would like an IEP meeting, and the school has to convene an IEP meeting to address your concerns. And so this is just a list of the parts of an IEP. Anybody who has a child with an IEP knows that the actual document can be very intimidating, and it can be really technical and hard to review and understand. And so this just sort of lists the different parts of an IEP, and we'll provide some resources, at the end of this training as well for parents to sort of understand all the different parts of an IEP. And so I'm going to switch gears a little bit and talk about behavior supports and discipline protections for students who have IEPs or 504 plans. And so the IDEA requires positive behavior interventions and supports to address interfering behavior. And so if you have a child who is having sort of disruptive behavior or interfering behaviors in the classroom, maybe they're being suspended, maybe you're getting those calls, your student's being suspended. The IDEA basically says, okay, there's two real tools that the school can use to sort of help support the student with these behaviors. And so the most proactive way to prevent disruptive behavior in school is through a functional behavioral assessment. Sometimes they're called FBAs, and behavioral intervention plans, or BIPs. And so the combination of an FBA and BIP is required when a child with a disability is removed from the child's current placement. So if a student is removed or suspended for more than 10 days, the school system has to do a functional behavioral assessment, followed by developing a behavior intervention plan. But I also want to say FBAs and BIPs can be used for general education students too. They are not only used for students with disabilities. So if you have a student without a disability who is repeatedly being suspended, you can call the school, ask the counselor, go to, the assistant principal and say, I have, concerns. My child has these challenging behaviors in the classroom. They're being suspended. I would like, a functional behavioral assessment. So it is a tool that can be used for all students. And the next slide, I'll sort of talk through a little bit more about what each of those things are. So the functional behavioral assessment is the first part. This has to happen first before a school team can develop a behavior intervention plan for a student. And so functional behavioral assessment means the systematic process of gathering information to guide the development of an effective and efficient behavior intervention plan for the problem behavior. It's the identification of the functions of the problem behavior. So the school team is collecting data and trying to figure out the root cause of the behavior. When is the behavior happening? What are the triggers for the behavior? What happens after the behaviors? And so it's the identification of environmental and other factors and settings that contribute to or predict the occurrence, non-occurrence, and maintenance of the behavior over time. And FBAs include the collection of hard data. Data is critical because that's what sort of allows the team to come together to get an understanding of when the behavior is happening and the root causes of those behaviors. And again, why are we talking about FBAs and BIPs? We're talking about them because they're two really important tools that school teams can use to support students who are being suspended repeatedly or who have behavioral challenges in the classroom. So once the school team conducts an FBA, and usually a functional behavioral assessment takes about 6 weeks because they're collecting data for about 6 weeks. And so after that data is collected, you come back as a team, as an IEP team, or as a student support team in the general education setting. You come back as a team and you review and you look at the data, and then you develop a behavior intervention plan. And the BIP describes the actions that the adults, the teachers will take to respond to the behavior and the replacement behavior that will be taught to the student and how data will be collected. So data continues to be collected. The legal definition of a BIP is a proactive, data-based, structured plan that's developed as a result of a functional behavioral assessment, which is consistently applied by trained staff, and that's key, by trained staff to reduce or eliminate a student's challenging behaviors and to support the development of appropriate behaviors and responses. Okay, so I'm going to talk about the suspension of students with disabilities. So students with disabilities have additional protections when it comes to suspensions, exclusionary discipline. And the reason for that is that students should not be punished for disability-related behavior. And so the law requires accommodation. And so if behaviors are related to the student's disability, they shouldn't be punished for those behaviors. And so that's why the IDEA, the special education law, and Section 504 have these built-in protections for students with disabilities. So for up to 10 school days consecutively or cumulatively in one school year, students with disabilities may be suspended just like students without disabilities. So for up to 10 days, the protections don't kick in. They can be suspended just like a general education student. However, if they're suspended more than 10 school days, that's when the protections kick in, and an IEP team must contact the parent, hold a manifestation meeting, complete or revise a functional behavioral assessment, and a behavior intervention plan. And so what is, a lot of times you'll hear a manifestation meeting or a manifestation determination review. And so what that is before suspending a student with a disability for more than 10 school days, and again, that's either consecutively or cumulatively. So if your child has 6 2-day suspensions, that, on that 6th suspension, they need to hold a manifestation meeting. So the IEP team, before suspending that student for more than 10 school days, the IEP team has to meet. And the team will review all relevant information in the student's file, any teacher observations, any relevant information provided by the parents and the IEP team, and they'll determine was the conduct that led to the suspension, was it caused by, or did it have a direct and substantial relationship to the student's disability? And then they'll also determine whether the conduct was the direct result of the school's failure to implement the IEP, which includes the behavior intervention plan. So those are the 2 questions that the IEP team is tasked with answering at a manifestation determination review. And so if the answer to either of those questions is yes, then the student is allowed to return to school. And this is so important. The suspension is terminated. They cannot continue to be suspended. They are returned to school because, again, we should not be punishing students for disability-related behavior when the law requires accommodation. So those students are immediately returned to school. There are 3 exceptions for drugs, weapons, and serious bodily injury. If the answer to either of the 2 manifestation questions is no, students may be suspended for more than 10 school days, just like any other student without a disability. The discipline protections kick in. They're going to have a meeting with the superintendent's designee. They'll still get all of those protections. And they have to continue to receive education services to enable them to progress in the general curriculum and advance toward achieving their IEP goals. And that's sometimes called FAPE services. And so the important thing to know, there's a lot on this slide, but the big takeaway is that students suspected of having a disability or students who are thought to be eligible for special education still get the benefit and the protections of that manifestation meeting. And so this slide sort of walks you through, if the school has knowledge that the student was suspected of having a disability, then they get those protections. And I'll skip to the next slide. And so if a parent disagrees with the manifestation determination decision or a student's change of placement due to behavior or a violation of the Code of Student Conduct, the parent can appeal the decision by requesting an expedited due process hearing. And this hearing, again, it's in the Individuals with Disabilities Education Act. It gives parents this right to appeal a manifestation determination decision if they think it was the wrong decision. And you have a hearing before an administrative law judge, and the hearing has to occur on a quick expedited basis, so within 20 school days of the date that the request is filed. That's good. And now we'll talk a little bit about red flags because I know we want to leave time for questions. So as Spencer had talked about, when we're talking about school discipline, push out, exclusionary discipline, there are definitely some red flags to be on the lookout for. And this, the red flags may be a signal that you might want to reach out to an attorney to, get some advice or a possible representation for your student. But some red flags are the illegal send home. So the school sends the student home for behavioral reasons, but doesn't treat it as an official suspension. School calls parent to pick up the child and records it as a walk-in. School tells the student to go home for the day. School places student on a modified schedule, a half-day schedule. Half-day schedules or modified schedules are illegal under the law, and that's a definite red flag. We also have a lot of schools call parents and say, oh, your child's having such a bad day. They're melting down. They're having a tantrum. It's better for them. Just come pick them up. And I know intuitively that sort of seems like, yeah, I should go pick up my kid. And it seems like, the school's looking out for you, but we actually advise parents, don't pick the child up unless the school is going to issue a formal suspension, because especially if you have a student with a disability, if they're not recording these illegal send homes as official days of suspension, then their protections at that 10-day mark aren't going to be, they're not going to kick in. So it's really important that if they're calling you to come pick your kid up, that you say, okay, well, are you suspending? And you ask for the paperwork. Another red flag, virtual learning. Teacher doesn't admit the student to the virtual classroom or requires the student to remain in a breakout room, or school forces a student to return to virtual learning for behavioral reasons. We're seeing an uptick in this, and schools aren't calling it a suspension. They're saying, you violated the code of conduct, you're going to go on virtual. But that under the law, that is a removal, suspension. And then also Spencer talked about administrative transfers to alternative schools. And this is just a slide of resources for parents. There's a Disability Rights Maryland School Discipline Manual, a special education rights manual. So if you have more questions about the special education process, I flew through that piece, but this manual is a good resource. And then again, the Maryland Suspension Representation Project provides free legal representation. Disability Rights Maryland is a partner in that. And then there's also some Know Your Rights cards.
Thank you both so much. That was incredible. And I would just let everybody in the audience know that you can absolutely put questions in the comments or in the Q&A. I certainly have a few. I'm also going to send everybody an email list or an email address. If you have questions for us, we can get you more information as well. It's cfcc@ubalt.edu. And we'll make sure that all of these resources are posted with links on our website as soon as the webinar is edited and posted on our website. That should take about a week or two. And so I don't see any questions in the Q&A or in the chat, but I actually have a few. So I don't know who wants to answer this, but you both talked about students being sent to alternative schools. And if that happens as a suspension and not as an expulsion, how do students get back to their school of origin? How are they how do they get that re-entry?
Yeah, I can take it, and then Spencer, you can jump in. So the only way that a student, should be transferred to an alternative school for school discipline is if they either receive an extended suspension or an expulsion. And there always has to be an end date. So when your child is suspended or expelled, it can't be indefinite. Under the law requires that suspensions are for a set specific time period. And so that is a red flag. If the school says, okay, you're sort of just suspended indefinitely, you should have a return date, a date when that suspension is over, or the expulsion is over. And so that is when, that end date is the date when the student should be returned to their regular education placement, their school of origin. And during that entire time period of the suspension or expulsion, as Spencer said, they're either in an alternative school or the school's providing them, with education work. And as a parent, I would reach out to the district and the school of origin to start talking about what is the transition going to look like, right? For putting supports in place to successfully transition the student back from the alternative school to the school of origin, because that is an absolute right. They don't just then start lingering in the alternative school. That doesn't become their full-time placement. They have a right to return back.
Yeah, and I'll just chime in and say my only experience with that has been with, so there's one example of an alternative program is Sharp Leadenhall Elementary, which oddly is not located in Sharp Leadenhall anymore. It's near Bel-Air Edison now, I think. But it is an alternative placement, I believe, for elementary and middle school age students. So that is a pretty common placement for students who are given an extended suspension. So that 11 to 44 day period. And then, as Megan said, there is an end date and they are supposed to return to the school of origin. Just as a practical matter, I found that parents often, as that suspension is coming to an end, often will try to find a different placement for their child. Often there's a reason that they don't want their child to return, either because they fear that the administration has already given up on this child, or there may be a bullying issue that led to the behavior that led to the suspension. So in my experience, at the end of those alternative placements, a lot of parents will either seek out a charter school or maybe a school where they're allowed to enroll out of zone.
Thank you. And are there resources to help parents find some of those schools if they are looking for them?
Megan may know of some. I don't know of any in particular, other than the district website, the Baltimore City Schools website is a wealth of knowledge. I mean, it gives you all of the options, and the Office of School Enrollment for Baltimore City Schools is always a good resource. Also, there's an organization in Baltimore called Live Baltimore. They have a great website that also lets you explore schools in different neighborhoods, and they have a school navigator who works full time to help families navigate the charter process and the high school choice process. So Live Baltimore is also a good organization to reach out to.
Thank you. Another question that came up, and you both talked again about pushouts. What can parents do if a school says, no, come pick up your child and I'm not going to issue the suspension letter? Is there anything that a parent could do? Would the Maryland Suspension Representation Project help with that? Are there other resources that parents could have?
Yes, absolutely. So first of all, it's a really difficult situation for parents because the school's saying, come get your child, but you're sort of being advised and under the law that you don't have to. And so it's hard and it's emotional, but we would say you can respond and say, I am not coming to pick up my child. I'm not picking up my child unless you're telling me that you're suspending them. However, if there's a pattern of this happening, and obviously that's a very stressful situation for any parent to be in, yes, absolutely. You can contact the Maryland Suspension Representation Project. You can contact Disability Rights Maryland's intake line. We do representation in school discipline cases through our intake line and through MSRP, and the other organizations in MSRP do as well. So yeah, I think that's a great. Especially if it becomes a pattern and it continues to happen, that's a red flag for sure. And you can seek help, seek assistance from an attorney.
And what if a student actually does want to go home? They are having a bad day, their anxiety is too much, and they just need a mental health day. Is there a way that parents and students could plan for that and actually find a way to say that it's the student's choice to go home and not the school's choice to send them home?
Yeah, that's a great point. I actually think there's legislation pending that would allow mental health days, like built-in mental health days for students. And so, but that aside, yes, if there is, I think that would be a time where you could, if the child has an IEP, you could bring that concern to the IEP team. You could bring that concern to the Section 504 team to say, this is what's happening. Maybe the team can find other ways to provide that student with a break within the school building. So they're not necessarily leaving the school building, but anyways, you could bring that concern to the IEP team. And if there is no IEP or 504, then I think you would just have a conversation with the administrators. And Spencer, you might have other thoughts as well.
Yeah, I think that's a great answer. And I do know just from my experience with our students who have IEPs, I mean, we have in the truancy court worked with students, especially high school students who had IEPs or 504 plans that specifically allowed for them to take breaks from their classroom environment, not to leave the school building, but to, go to a counselor or go to another space that's not being used or go assist the librarian with tasks. So I have seen that written into IEP plans.
Yeah, absolutely.
And then one more question for parents. We talked a lot about the IEP team and parents being a big part of that. Do parents have to be alone at those IEP meetings, or can they bring support? Can they bring a lawyer? Should they bring a lawyer? Some of those questions.
Yeah, another great question. So no, parents, you do not have to go alone. Again, the actual IEP document is intimidating, but it is very intimidating walking in or going into a Zoom IEP meeting. Either way, there's all of these, school people and the parent, and it can feel very scary. So you're absolutely able to bring support, a family member, a friend. A lot of times, we'll have parents bring pediatricians or maybe an outside counselor. We have, clients who have really great relationships with their outside counselors, and then that person can come and be an expert, can really sort of help advocate for the student and the parent and shed some light on, on the student's disability. So yes, absolutely I would encourage it to bring a support.
It's also important to bring support because you certainly have the right to bring an attorney to the meeting, especially if you anticipate that things may escalate. But generally speaking, the school district will send their own attorney if they know that you plan to bring your own, or sometimes they may postpone the meeting. I have also heard of them doing that to make sure that a school district attorney can be present too. So at first, I would suggest what Megan is saying, bring someone supportive, but maybe not necessarily an attorney to the first meeting. But definitely, if you're not getting the results that your child deserves, then it's time to get an attorney for sure.
Well, thank you both so much. I'm not seeing any other questions. I could probably go on and ask 100 more, but I know you both had very long days. So thank you so much. I just want to point out that I put a few links in the chat, but I will say them verbally as well. This webinar will be posted on our CFCC website. The link for that is law.ubalt.edu/centers/CFCC. That's the Center for Families, Children, and the Courts is the acronym. We'll also be emailing it out to families, and please share with your friends. And we'll post all of the resources that both Megan and Spencer mentioned on our website as well. So thank you all so much for being here, for joining us this evening. Megan and Spencer, thank you so much for your wealth of knowledge. I learned a lot tonight, and I've been doing some of this work for many years. So I appreciate both of you. And thank you very much.